खानदानी लुटेरों की कोशिश होगी बेकार। फिर एक बार मोदी सरकार।
The Kolkata High Court made strong remarks on Tuesday regarding the ongoing violence and unrest in the Murshidabad ahead of the second phase of voting in West Bengal. The court stated that it would urge the Election Commission to postpone the elections in Murshidabad. Chief Justice T.S. Thakur expressed during the hearing regarding the violence on Ram Navami Day, where the people cannot peacefully celebrate their festival for 8 hours, there is no need for voting at this time. This comment during the hearing on Tuesday in the High Court puts a big question mark on the Mamata government and its administration. The Supreme Court conducted a hearing on Tuesday regarding the controversial Patanjali advertisement summoning the Indian Medical Association for questioning. During the proceedings, the court questioned the IMA on why allopathic doctors prescribe expensive medication of specific brands and whether there is provision for cancelling the registration of doctors who intentionally prescribe costly medicine. Additionally, each state's drug licensing authorities was also brought into case by the court. Furthermore, Baba Ramdev and Acharya Balkrishna were directed to increase the advertisement's font size and highlight the apology during the hearing to ensure public comprehension. They are scheduled to appear in the Supreme Court again on April 30th. The Supreme Court emphasized that the matter won't be limited to one organization and questioned the government about its action against other companies involved in misleading advertisement that pose threats to public health. It's worth noting that the Supreme Court had previously rejected Patanjali's apology on April 10th and earlier on April 2nd. Delhi CM Arvind Kejriwal's judicial custody in Delhi liquor policy scam money laundering case has been extended until May 7th by the Delhi's Rouse Avenue Court. Alongside Kejriwal, BRS leader Kavita's judicial custody related to CBI case in the liquor policy scam has also been extended until May 7th. Additionally, the judicial custody of the accused Chanpreet Singh has been extended until May 7th as well. After the completion of their custody period on Tuesday, all three were presented in the court via video conferencing. In the Bombay High Court, IRS officer Sameer Wankhede has filed a petition against irregularities in the NCB's preliminary investigation into drug cases, including those related to actor Shashank Singh Rajput's death. On Tuesday, the bench of Justices Revati Mohite Dere and Manjusha Deshpande rejected the acceptance of a 4,000-page compilation by Sameer Wankhede's legal team officer. During the proceedings, the bench commented, "Just give us relevant pages, don't waste paper. We are scared of this. We are not even putting it on record." The court will hear this petition on May 2nd, 2024. Minister Rajiv Chandrasekhar filed nomination papers along with false affidavits. Justices V.G. Arun and S. Manu rejected the use of writ jurisdiction on Tuesday, stating it's hand-tied as the election process has already begun. The petitioner had alleged that Minister Rajiv Chandrasekhar concealed his financial assets and misinterpreted his income in the affidavit filed with his nomination papers. Meanwhile, the Election Commission's government lawyer argued that a writ petition is not maintainable under Article 226 and suggested filing an election petition instead. On Tuesday, the Supreme Court's bench of 9 judges began hearing on whether private property can be brought under the category of community resource. This pertains to private landowners in Mumbai resisting the Maharashtra government's effort to take over the dilapidated buildings for renovation. The central question before the Supreme Court is whether private property can be considered a community resource. Article 39B of the Constitution suggests making laws to ensure the distribution of resources for the benefit of all citizens, but it's not clear if private property falls under this. Chief Justice pointed out that Article 31C still exists alongside 39B. If the Article 31C is not there, then there is no question. The Solicitor General argued that Article 31C is still valid, citing principles of policy directives as a personal provision. He referenced a 2002 ruling by a bench of 7 judges in the 1996 Property Owners Association case, which referred the current issue to the bench of 9 judges. After extensive discussion, today's hearing concluded with further proceedings scheduled for tomorrow.